In exchange for that plea, the people will dismiss count number 1 of operating while intoxicated causing death, which is a 15-year felony, and count number 2 of operating while intoxicated causing serious injury. That is a 5-year felony, and the habitual offender third notice, which would make that 15-year felony a 30-year and the 5-year a 10-year. Is that your understanding of the plea agreement?
Yes, sir.
Back on January 22nd of this year, were you on probation or parole?
No, sir.
Were you on bond in any other file?
No, sir.
Do you understand that you had the right to have an attorney, the right to a trial, either by judge or jury, the right to have witnesses called for your defense at trial, the right to cross-examine all witnesses called against you, This is case number 262823FD. Appearances, counsel?
On behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Hilton. He's now joined me at the table. He's seated beside me.
All right, counsel, we are here for preliminary examination on looks like a 2-count complaint. Is there any resolution to this matter?
Yes, Your Honor. It's my understanding the defendant will be pleading guilty to operating while intoxicated, a 93-day misdemeanor. The people will be dismissing the charged counts. I did also communicate to defense that the people will be recommending time served as well as probation. That is just a recommendation, not a sentence agreement.
Mr. Harrison.
That's my understanding as well, Your Honor.
I'm sorry, Mr. Carnes, it was time served without probation?
No,
with probation. And is this a OWI under the influence of a controlled substance?
Yes, Your Honor.
All right, Mr. Hilton, have you heard what the attorneys have said the resolution of this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand as best as you're able? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
So have you had adequate opportunity to discuss this case with Mr. Harrison and feel comfortable in entering a guilty plea today?
Yes, sir.
So it's my understanding that you'll be pleading guilty to operating while intoxicated, which is essentially an added count 3. That is a misdemeanor punishable by up to 93 days and or a fine of between $100 to $500. Additionally, the prosecution will recommend time served with probation. Do you understand that as long as they make that recommendation and I don't follow that, you would not be able to withdraw your plea as long as they make that recommendation? Do you understand that? Sorry.
Yes, sir.
In exchange for that plea, the people will dismiss count number 1 of operating while intoxicated causing death, which is a 15-year felony, and count number 2 of operating while intoxicated causing serious injury. That is a 5-year felony, and the habitual offender third notice, which would make that 15-year felony a 30-year and the 5-year a 10-year. Is that your understanding of the agreement?
Yes, sir.
Back on January 22nd of this year, were you on probation or parole?
No, sir.
Were you on bond in any other file?
No, sir.
Do you understand that you had the right to have an attorney, the right to a trial, either by judge or jury, the right to have witnesses called for your defense at trial, the right to cross-examine all witnesses called against you, the right to testify or to remain silent, and if you choose to be silent, not to have that silence used against you, the right to be presumed innocent, and the right to be proven guilty beyond a reasonable doubt. Do you understand all those rights?
Yes, sir.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up those rights? You won't have a trial of any kind.
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Counsel, this is a guilty plea and not a no contest plea?
I would be happier with no contest. I don't know. That first one is in the police, the initial police report, isn't it? If the court would indulge that, that would be,
Well, I mean, I can see where a not guilty plea certainly has grounds here, but that's up to the prosecution as to how they want to handle their plea.
a potential civil liability.
I will resolve with a no contest plea.
I appreciate that accommodation.
So, Mr. Hilton, it sounds like the plea in this case is going to be modified a little bit. So instead of pleading guilty, you'd be pleading no contest. What that means is that you agree to accept responsibility without saying that you are guilty. The court's going to be able to review a document, maybe a series of documents. My guess is it's probably going to be police reports and lab reports to determine whether or not there's sufficient evidence to find you guilty of operating while intoxicated. I would be able to use that for both the factual basis and for sentencing purposes. Do you understand that?
Yes, sir.
Now, the reason for the no contest plea would be potential civil liability. And the court can see where there'd be civil liability arising out of this transaction. If you plead guilty, that guilty plea would be able to be used against you in a civil case. But by pleading no contest, that would not be the case. It would not be able to use that against you. Do you understand that? Do you also understand that what's contained in these documents that I'm going to review, I get to take as the gospel truth, and that you are not able to rebut the facts that are contained in that those reports and documents? Do you understand that? Knowing all that, then, you wish to change your plea to a no contest plea?
Yes, sir.
All right. Are counsel aware of any other promises, threats, inducements not made part of the record?
No, yeah.
Nor mine.
Then, Mr. Hilton, to the allegation, I'm sorry, Mr. Carnes, we do need the PAT code for this plea. Doesn't appear that our new system had transferred that over. 257-625.
I just want to make sure abstract's correctly under controlled and alcohol.
Okay.
Yeah.
2A.
257.6252A.
All right, then, Mr. Hilton, to the allegation that on or about January 22nd, 2026, in Clam Lake Township of Wexford County, Michigan, how do you plead to an added count 3 of operating while intoxicated by a controlled substance?
No contest.
Counsel, I've been provided with what has been marked as People's Exhibit number 1, 2, and 3. People's number 1 is a Michigan Department of State Police incident report number 001-000028-26. Mr. Carnes, you're on your feet.
Your Honor, I just want to make sure I gave you the right report. Is that?
Yeah, there's 2 of them with the supplements.
Your Honor, my apologies. That is not the right report. I will.
All right.
Actually, does the court have the probable cause statement from this still?
I do have the probable cause statement, but you're not going to want me to review that. You're going to want me to review a report.
All right.
All right, so we'll try this again. People's Exhibit number 1 is Michigan Department of State Police Incident Report 071-000-223-26. People's Exhibit number 2 is a State of Michigan Department of State Police Forensic Science Division Laboratory Report number TX26-1456. And People's 3 is State of Michigan Department of State Police Forensic Science Division Laboratory Report number TX26-1456, Record 3. And I'm sorry, People's 2 is Record 2. Mr. Carnes, are you moving for admissions of People's 1, 2, and 3?
Yes, Your Honor.
Mr. Harrison?
I would encourage the court to accept them without objection.
All right, People's 1, 2, and 3 are received. Give me a moment while I review those reports. Mr. Carnes, do you have anything to indicate what road conditions were like? Well, I see a weather report downloaded from GUARD. One, I can't read it, and that doesn't necessarily tell me what road conditions were. I see the road setup, but if somebody can point me to road
I
conditions.
thought it was in this section.
Looks to me like they are probably most fully discussed in the report I gave you. I do have the accident investigator report, but that's not. That's the event data recorder report, not a road condition.
Sorry, I do see it now. It's on page 1 of supplement 1. I apologize. Will council approach? All right, council, after having had sidebar regarding the exhibits, Mr. Carnes had asked the court to take also into account the consideration of the affidavit of probable cause. Mr. Harrison hadn't seen that in its entirety. We gave him the opportunity to review that. Mr. Harrison, are you asking the court, or do you have an objection to the court taking, considering the affidavit of probable cause as well?
I do not, Your Honor, under the circumstances that this case presents.
To be safe, can we get this marked as exhibit 4? Mr. Carnes, are you moving for admission to exhibit 4?
Yes, Your Honor.
Any objection to that, Mr. Harrison?
I have no objection to that document, Your Honor. Pardon me.
All right, do counsel believe that People's Exhibits 1, 2, 3, and 4 form a factual basis to accept the plea to operating while intoxicated by a controlled substance, and that the court rules have been complied with?
Yes, Your Honor.
I'm satisfied that is the case, Your Honor.
Mr. Harrison, based on the conversation we had at sidebar, are you waiving any defenses in regards to any other cause that would appear the defendant, that would have the defendant appear to be intoxicated, such as injuries from accidents or anything like that? You're waiving.
We don't intend to raise anything like that. We'll gladly waive them for the purposes of this plea.
All right, the court does find, based on the combination of all 4 exhibits, that there is sufficient evidence to find the defendant guilty of operating while operating while intoxicated. In particular, People's Exhibit number 1 indicates that law enforcement were called to an area on M115 near South 45 Road in Clam Lake Township of Wexford County on January 22nd at approximately 2 o'clock in the afternoon. The report does make out that there was road conditions were ongoing, snowfall, wind gusts were causing blowing snow and poor visibility. Ice pack and snow pack on the roadways were causing poor traction and substantially greater stopping distances as required. There was an accident that did occur. There was a person who was driving a 2019 Subaru Forester. And then there was the defendant who was driving a Dodge Ram. The defendant lost control of his vehicle and collided with the Subaru Forester. That did result in the death of one individual. A blood draw was taken by law enforcement and sent to the crime lab. That does come back that the defendant had THC in his blood, Delta 9 THC, 16 nanograms per milliliter, and also came back with a gabapentin in the system, which if the court recalls is a control 4 under Michigan. So therefore I do believe, and obviously THC in Michigan is a Schedule 1. In regards to the signs of intoxication, which is why the court is going to rely on People's Exhibit number 4, it indicates that the troopers noticed that Mr. Hilton's eyes were slightly bloodshot as he spoke to him. His eyes were only partially open for much of the conversation. And based on his interaction and experience, the trooper suspected that he was either under the influence of alcohol or a controlled substance or some other intoxicating substance. Based on all of that and the defendant's waiver of any defenses, I do find the defendant guilty of operating while intoxicated pursuant to the plea agreement, the operating while intoxicated causing death, the operating while intoxicated causing serious injury, and the habitual fourth will be dismissed at the time, habitual third will be dismissed at the time of sentencing. Counsel, I know we've had a substance use assessment in this matter. I've had the opportunity to review that, but given the nature of the allegations, I would request that we do a PSI in this matter. Mr. Carnes, I know that there's some people here. I didn't know if you wanted to take any victim input statements now or if you want to wait on that.
I would leave that up to the victims. I certainly ask the court to consider taking them now. They're all here.
Do you want a moment to talk with him about that?
Sounds like Michael wants to give his, and I just ask if I can ask Kyla real quick. Ms. Beerquist, do you prefer to give your statement now or at sentencing, which would be in about a week?
Probably a couple weeks out.
I'm not sure which would be best, but I am prepared today to make a statement.
If you're prepared today and you feel comfortable doing that today, you can always come back and do it at sentencing. The preference is yours, honestly.
I think I would rather do it in person, Your Honor. I'm currently traveling overseas, and I was expecting to be there in person today to support my mother, and I'm really upset that I can't be. So if I could come and speak in person, that would be best. Thank you.
Mr. Carnes?
Your Honor, obviously, whatever Ms. Beerquist wants, I am in favor of. I am hearing from Mr. Beerquist that he would like to make the statement today.
All right, so let me make some notes here. So we're going to set this over for a substance use assessment. I'm sorry, pre-sentence investigation report. I'll also mark for victim input because Ms. Beerquist wishes to address in person. All right, so I'll hear from Mr. Beerquist. All right, so you can have a seat there. If you could state your name for the record.
Michael Beerquist.
All right, and what is it that you would like me to know?
I wrote it all on.
Sure.
Your Honor, my name is Michael Beerquist, and I am the son of Noel Diane Beerquist. There are no words that can fully describe the pain of losing my mother because of the defendant's decision to drive under the influence. In one moment, my family was forever changed. My mother wasn't just another person. She was our foundation, our comfort, and someone who loved us unconditionally. Her death took away so much more than her life. It took away my chance to continue making memories with her. It took away my newborn son's opportunities to know his grandmother, to be held by her, to hear her stories, and to experience the love she would have given him every day. He will only know her thoughts, her through paragraphs, photographs, stories, and the memories we share with him. My sister and I have had to learn how to live with a loss that never goes away. Every birthday, holiday, family gathering, and milestone is a painful reminder that our mother should be here. The grief doesn't end after the funeral. It becomes something we carry every single day. No sentence can bring my mother back or undo the choices that led to her death, but I hope the court understands the lasting impact this has had on our family. One decision to drive under the influence has left a lifetime of heartbreak for those who loved her. I ask the court to consider the devastating consequences of the defendant's actions, not only the life that was taken, but the lives that have been permanently changed because of that choice. My mother deserved to grow old, watch her grandchildren grow up, and continue being the heart of our family. That future was taken from her and from us. My mother was a joyful person who could bring a smile to anyone in the room without trying. She was a locally known person. Some would say a saint, some would say a goofball or a great waitress from her years. But she was never known for bad reasons, and that is how we will continue to remember her. No matter what happened, she was the person who never looked down on me or walked away from me because of that loss. I now struggle to communicate with any living being. Thank you for allowing me to share how profoundly my mother's loss has affected my family.
Thank you. Ms. Veracruz, I see you have your hand up. Do you wish to make a statement today?
Your Honor, I just want to ensure that I will be able to make a statement when I come back, and if not, that I would be granted to do so now.
So when are you back in the able to attend?
I will be traveling back to the U.S. on Saturday, August 8th.
So we'll have this set for the 19th, so you should be back.
Okay, thank you, Your Honor.
All right, thank you. Mr. Carnes, do you have anybody else who wishes to address the court?
No, Your Honor. Thank you.
All right, Mr. Harrison?
Your Honor, in light of the extension of time between now and the 19th, I would like to be heard on bond.
I'm sorry. Any objection, Mr. Carnes?
No, Your Honor.
He has entered and thus been convicted of a 93-day misdemeanor here. He has built some substantial jail credit. This in no way diminishes or should diminish the impact of any victim statement or anything like that that we may hear in the ensuing days. But I don't see the utility in maintaining him in jail. He will be seeking employment immediately upon his release. That's what he's always done. And he will continue to take care of his elderly mother, which is of great concern to Mr. Hilton. I would simply ask the court that he be released PR with the original conditions you had put on the bond at the beginning of time, which I believe was random testing and the usual surrounding circumstances. Thank you.
Thank you. Mr. Carnes?
Your Honor, just for the sake of the victims, I want to acknowledge that the defendant's bond conditions of do not use marijuana, illegal substances, and random testing would remain in place. I will take no position on bond. Thank you.
All right, thank you. The defendant was before this court on July 14th for an arraignment. Bond was set at $50,000 cash surety with standard conditions and conditions not to use drugs, recreational marijuana, and subject to random testing, along with GPS tether, house arrest, and not to act any threatening, intimidating, or harassing behavior. Now that the defendant has entered a plea in this matter, he's not necessarily entitled to bond, but I am also aware of the presumption in these cases for OWIs that there's a presumption of no jail and no probation. However, that is a rebuttable presumption. And looking at the defendant's history, I show in 20 there was a domestic violence, in 94 loitering, obstructing without violence. There was also, I can't read my notes, I think that says 14, a possession of marijuana. In 2000, a driving while under the influence or DUI, possession of marijuana less than 20 grams, possession of a controlled substance, paraphernalia, reckless driving out of 05, a domestic battery in 12. So I do believe there, along with the defendant's assessment that I've read in anticipation of today, I believe that that is that rebuttable presumption can be gotten over. However, at the time of the arraignment, the defendant was facing a 30-year felony. Is now subject to a 93-day misdemeanor. So the court will modify bond. Bond will be modified to a $10,000 cash surety with the same conditions as previously set. Except I will add EOP. Is there anything else for the record, counsel?
Nothing further. Thanks.
All right, thank you. Mr. Carnes, your exhibits. I obviously will hold on to the probable cause affidavit.